The man accused of trying to assassinate Donald Trump at his Florida country club in September will not be facing trial until almost a year after he was arrested. CBS News legal contributor Jessica Levinson joining us now. Jessica, first of all, great to see you and talk to you again. It's been a while. I want to ask you, the suspect's attorney had asked for more time to mount an insanity defense. For a regular person watching this, it feels like, wow, this is an incredibly long time since this all happened. Is a delay like this unusual, or is it pretty normal based on what he's charged with here?
Well, both, in the sense that an insanity defense is not a typical defense, and that takes some time. You need to get all of the evidence, and you need to get expert testimony here. What the judge in charge of the case, this is Judge Eileen Cannon. Some people may remember her because she was the federal judge in charge of the Mar-a-Lago case. What she said is, basically, come back to me by February with some initial conclusions about whether or not you are actually going to move forward with an insanity defense. So she has provided some timeline, some deadlines throughout the way. She also did not give the defense everything they wanted. They said, let's not even do anything for a year from now. She said, I think September is soon enough. Or gives you enough time. But an insanity defense is very hard to mount. We should remember that it includes not just the defendant showing a significant mental defect, but also that the defendant didn't understand that what he was doing was wrong. And there's a lot of evidence to undercut that here.
Right. And I'm sure that if that's the case, we will hear what that evidence is. But of course, the public wants answers right away. It just seems like that's not going to happen here. And Jessica, since we have you, we're also seeing that the mother of the teen who killed 4 people in the Oxford, Michigan high school shooting is asking a judge to be released from prison. Jennifer and James Crumbly were the first parents to be held criminally responsible for a mass shooting committed by their child. That made a ton of headlines. So now Jennifer is arguing that that she should be out on bond during her appeal, and her attorney is saying that she shouldn't have been prosecuted in the first place. What do you make of this?
Well, this is typical. I mean, basically every defendant who's convicted will appeal. As you said, this is a first in the nation type of situation where she was found guilty of involuntary manslaughter, and she was found to be criminally liable based on her own conduct. Essentially, the jury found there were so many red flags that she should have taken action, not vicarious liability, but her own liability, that she should have taken action to prevent these tragedies. Now, it's very unusual that someone would be released pending appeal based on this type of conviction, but she's basically moving forward with, there's a reason this is first in the nation, because you shouldn't make somebody like me, who didn't actually pull the trigger, criminally liable. And we'll see on appeal if that argument has any traction.
Yeah, this could set some precedents. Jessica Levinson, CBS News legal contributor, always great to talk to you. We hope to see you soon.